Good morning, ladies and gentlemen, and welcome to our Labour Law Chambers webinar. This is our 9th episode already, and it will be the last one for the year. And I'm Vaughan Buerta, and today with me I have Jacqueline Azel. She is our Labour Law Consulting Manager. And we are also very pleased to have a special panelist, Prof. Rona Newmark, who is attending and who will be discussing this intriguing topic with us today. Jacqueline, Rona, good morning.
Good morning.
Well, today we're going to be chatting about dishonesty in the workplace, and we're going to be discussing it both from a legal and a psychological perspective, and hence why we've got Professor Newmark with us as a guest speaker to collaborate with us on that topic. For the attendees, please know that we are recording this session and we'll be uploading it onto our YouTube channel in case you can't watch it. And what we've also done, considering the topic and all the detail we want to cover, is we've extended it from our normal usual hour and 15-minute slot to an hour and 30-minute slot. So in case you haven't noticed that, and in case you need to run, please know that we're going to be recording it, and we will probably publishing it within 7 days of today. And we've also allowed for some questions and answers afterwards. Throughout the session, please feel free to post your questions in our chat box, and then at the appropriate time, we'll share that with the panel and get the insights accordingly. But before we proceed, Prof. Newmark, can you maybe give us just a quick snapshot of who you are and what you're busy with, perhaps? Oh, I think you're on mute. Sorry.
My apology for that. Thank you for the opportunity. I have a history in academics, and currently I'm full-time in practice as a psychologist and a commercial and family mediator in Cape Town region.
That's brilliant, Prof.
I must say,
during our introduction discussions, I think the common theme has been that our workplace is becoming much more complicated. I think, when we spoke casually, we spoke about social media, we spoke about influences or personal influences that come into the workplace. And I've always had this thought, as employers, we often think that our employees walk into our office, and once they close their door, they leave their personal lives behind. And that's not the truth. We come with everything to the workplace, and hence why there's probably a correlation. Our personal lives are becoming more complicated, and definitely from a legal perspective, we're seeing that the workplace is following suit. And just as an example, in the past 2 years, we've seen cases of very sophisticated forms of crime and dishonesty, from trucks being stolen to sophisticated drug syndicates being run in companies. And what's very interesting to me with that is it's become very sophisticated and intentional. It's not by accident, and it's not like Jacqueline's going to be dealing with that one slide in terms of white lies. No, I made a mistake, so I'm going to try to cover it up. Very sophisticated, intentional types of deception that we're noting in the workplace. So we're very intrigued to get your comments today. And Jacqueline, without further ado, if we can start with your legal perspectives. For the attendees halfway through, we've got the legal portion or legal portfolio we're going to be dealing with, and then halfway through, we're then going to be giving over to Prof. Newmark to be sharing her insights. So without further ado, Jacqueline, over to you.
Thank you, Vaughan. Good morning, everybody, and thank you for setting aside the time to be with us this morning. I would like for you to start off and picture in your mind's eye, if you think about a traditional Christmas fruitcake, what is it that you think about? Now, if we're going to bake this fruitcake and I decide I'm going to use what I have in the house, and I'm going to use banana, and I'm going to use mango, and I'm going to use papaya, I can promise you I will not end up with that traditional Christmas fruitcake, although I used fruit. So, therefore, I'd like you to think of this tree of dishonesty bearing different fruits. So we've got different forms of dishonesty, but essentially they are not the same. So we can refer to the following examples: theft, or just stealing things, unauthorized possession, unauthorized removal, where there's fraud or falsifying information or documents, telling lies, just normal lies, misleading the employer, or non-disclosure, where we are deceptive by keeping information to ourselves, which is important for the employer. Some of you might have watched our previous webinars on the flow of a disciplinary hearing and the law of evidence. It's on our YouTube channel. It might be worth your while to go and watch it, because there we elaborate a little bit more as to from where the incident took place to formulating the charge to going into the hearing, what is important. So you would typically have an incident, and now you must think, which of these fruits, what name are you going to attach to this incident? Although theft and unauthorized possession respectively may be forms of dishonesty, the requirements to prove the transgression can be very different. And now you'll see my comment in red where I say the chairperson is not in a position to correct a charge where the elements that need to be proved are different. There are some instances, according to the Eon case, where if the charge wasn't that nicely drafted or formulated, the chairperson has got a little bit of wiggle room. What I want you to bear in mind is when we talk about stealing and fraud, for example, we are talking about actions that can also constitute a criminal offense. So coming late, taking extended breaks, being unprofessional at work, when we draft those charges, it's not as pedantic as when we deal with charges that can also be a criminal offense in terms of criminal law. That is why this topic is also important this morning. So one of the first things that I would recommend is not all of the people in a workplace that are sometimes tasked with investigating an incident and taking that up to a hearing is formally legally trained. So in order to help you, I would suggest that you use alternative charges. For example, if you're not sure whether this was theft or possession or removal, you can draft as follows, and you can say unauthorized possession in the alternative unauthorized removal of the company emergency cellular phone, or theft in the alternative unauthorized possession. You might not know whether you're going to be able to prove that intent that theft requires, but surely the person did have something in their possession or removed it from a particular place and they weren't allowed to do that. So the alternative charge then gives your chairperson the option to apply the facts and the elements to the evidence, instead of you ending up with a not guilty plea because you did not know about these technical elements when we talk about these transgressions.
Jacqueline, if you can just share your slides with us. Sorry, I don't think you've shared it. And I'll maybe just make a comment in the interim for our attendees whilst you do that. We recently had that Eon case where that particular element was brought up, where the categorization of the charge was incorrect. And fortunately, what our courts have acknowledged is the fact that employers are often not legally trained and they wouldn't know better. And, Jacqueline's comments is great because it's best practice. And I think our legal attendees on this call today would understand the method of using the alternative charges. But for employers, I think our courts have assisted us very much with that Eon case of recently. There we go. Jacqueline, you are live again.
I apologize. It did stipulate sharing.
No problem.
So I just went through the motions to reshare. I apologize for that. All right. So
no problem.
If we then look at fraud as an example of dishonesty, I'm going to refer to a couple of court cases as we move through the information, because it will also tell us how the court view the different types of transgressions. So what is important is that the Labour Court said in the Netcall case, dishonesty is not a loose term that you can just slap onto any type of conduct. But the Labour Appeal Court also says dishonesty entails a lack of integrity, straightforwardness, and it's in particular a willingness to steal and cheat and lie. So the court is quite expressive about how resentful these actions could be. So if we then take a look at how much detail do we need if we talk about fraud, for example. Fraud is often, and I specify often, it can be, it's repetitive conduct. So maybe there's somebody who's creating false invoices, they added their bank details, they send it to different clients, or they repeat this every month. What we see in the court case of mutual construction is on your notice for the disciplinary hearing, you do not have to list all 50 incidents. So an example of what you could do when you formulate your charge is to say fraud, in the alternative theft, in that during May 2024, you made unauthorized changes to the closed payroll and benefited financially from other employees' earnings, right? So this is a very safe way to formulate the charge because the person who is being charged will know what they are accused of, the period when they are allegedly accused of doing this. The fact that you say changes means this person knows it wasn't just one incident, right? Because your charge also needs to give enough information for the accused to know how and what to prepare. If we look at unauthorized possession, this is where the employee is found with an item in their possession and they do not have permission to have that company property, right? So interesting for me from the court case as well is that the court says it's very difficult to imagine that every time somebody commits these type of offenses, that you first have to give them another chance and another chance, all right? The court is very serious about these type of transgressions. And the court says dismissal for a first instance of such misconduct was fair in this instance, right? You will see as a golden thread through the cases, and I'll read from this quote in the APSA case, the court said, dishonesty has a corroding effect to the trust which the employer is entitled to expect from its employees in the various operations. So if you think about the foundation of everything between the employer and the employee, it comes down to trust. And some of you who've already baked or know how baking works, it's like the moment you open that oven while your cake is still rising, everything will fall flat. So what the court essentially says is the moment that an employee commits one of these dishonesty-related offenses, it immediately takes away that foundation of trust and the house will implode. We also have incidents where people misrepresent information. And this Exoro case, the mine provides subsidized accommodation to people who do not have their own housing within a radius of 50 kilometers. So Ms. Mutiba was an employee at the Groot Geluk gold mine, and she lied on an affidavit to obtain subsidized accommodation. She claimed that she did not own property within the 50-kilometer-mile radius. The mine dismissed her, and the court upheld the dismissal and again emphasized the importance of trust in the employment relationship and the irreparable damage caused by misrepresentation and dishonesty. So here's just another example of how people, she didn't steal anything, she didn't manipulate any information, but there was a blatant lie. So the question then is, how serious is dishonesty? If we see what the court says, just two more examples. In the Boschendal case, the court says, this trust which the employer places in the employee, it forms this foundation and it goes to the root of the employment contract, right? In the Toyota case, some of you who've been in disciplinary hearings, we always deal with mitigation and aggravation. And one of the prominent mitigating factors is, for example, long service, where somebody's been in a business for 10 or 15 years, the disciplinary record might be clean. The court says in Toyota SA Motors, although a long period of service of an employee will usually be a mitigating factor where such employee is guilty of misconduct, The point must be made that there are certain acts of misconduct which are of such a serious nature that no length of service can save an employee who is guilty of them from dismissal. And then the court says, or the judge, to my mind, one such clear act of misconduct is dishonesty, right? So not even long service can save you if the dishonesty is of a serious nature. I don't want to stand still here long. Schedule 8 of the LRA lists the big 5. What do I mean by the big 5? It says, if a person is found guilty of, for example, willful damage to property, willful endangering of the safety of others, physical assault, gross insubordination, or gross dishonesty, you might end up dismissed even if it's your first offense, right? But note, it says gross dishonesty. So you can always use Schedule 8 of the LRA and the big 5 as a bit of a check and balance when you need to evaluate. Vaughan always says, are you going to give that kill shot? You know, big 5, kill shot. I'm sure it will stay in the back of your mind. It must be one of the big 5 before you can even consider maybe pulling that trigger for a first offense. So we've now seen the court regards dishonesty in general as very serious, but there's also degrees for dishonesty. So gross dishonesty, according to the Moorddrift dairy case, says it implies a deceptive action which does harm the company. So harm the company is one key point. And although dishonesty does not automatically carry the capital punishment, that kill shot of dismissal, in this case, the dishonesty involved large sums of money and it resulted in a loss for the company. So there are more key pointers for you to determine the dishonesty that took place, be it one of those fruits, theft or misrepresentation or fraud. Is it so serious? Did the business suffer harm? Did we have a loss? Was large sums of money involved? Those will be your indicators whether you could possibly consider that dismissal sanction. And like Vaughan mentioned at the start, the court does recognize the existence of what we would call a white lie. So in the Standard Bank case, the employee told a lie to not get a warning for something else that he did or she did, right? And the CCMA said the employer was good to go with the dismissal for this white lie, but the Labour Court said no. In bold, you'll see there, the court said the lie told by the applicant was occasioned by the irrational fear and panic of having a complaint laid against him. The lie and the conduct on the part of the applicant did not prejudice the first respondent, which is the employer, in any way in real terms. The court says the white lie is defined as a lie that does not go to the heart of the trust relationship. In considering the circumstances in this matter, the applicant was not guilty of dishonesty, but rather telling a white lie. I do understand that this makes matters difficult because now not even dishonesty is just black and white. There are degrees. But we have these pointers from the LRA and from the case law that we could draw on to weigh up and assess what is it that happened here. Did it really make our cake fall flat? Is the foundation of trust completely gone? Did we suffer a financial loss, lots of money, maybe a lot of reputational damage or harm? Then maybe it's not just a white lie anymore. Right, then I briefly want to touch on to just the impact of criminal records. We are dealing with aspects that are more criminal in nature today. So just to also give you this background before I hand over to Professor Newmark in a couple of minutes. Criminal records are often used by employers or recruitment agencies to either turn down a job applicant or to retract an offer of employment or to even terminate an existing contract of employment. I'm going to briefly unpack each of these scenarios. Often employers will obtain the applicant's consent to do criminal and credit checks. What is important in terms of the Protection of Personal Information Act it's not always justifiable to even ask access to the information. So the inherent requirements of the job will determine if it's justifiable to ask the person's permission to do a criminal and or a credit check. So if the criminal check does show that there is a record, what we see in practice in most instances, the employer will decide not even to progress with that recruitment phase and not even invite the person to further interviews, for example. Now, the question is this discrimination or not? What we see in the LRA is that although a job applicant is not an employee yet, the LRA still protects job applicants against unfair discrimination. That's very important to bear in mind. The other aspect that is important is as soon as a contract is signed, the applicant will become an employee, even if the person hasn't worked a day yet. So let's say, for example, Professor Newmark offers me a job to start with her in January because she's going overseas for 2 months. We sign the contract today. Even though I haven't set foot in her office, I haven't done one piece of work, I am already her employee because I signed the contract, right? Just bear that in mind. What often happens is the employer is very keen about this applicant, the CV is great, the interviews went well, but now it's going to take a bit of time to do that criminal check. So the employer will send an offer letter to the applicant and say, we are very happy to offer you this opportunity subject to your criminal check coming back clear, right? So that offer is subject to a condition. If that criminal check then comes back and there is a record, and the employer then says, listen, we are going to retract that offer, we're doing this, no more offer for you, that does not constitute a dismissal because the contract wasn't signed yet. That offer was subject to this condition being met. Right. A very recent case that illustrates all of these examples is O'Connor versus LexisNexis. It's 2024, so it's really very recent. The applicant applied for the senior data discovery expert position at LexisNexis. So this applicant would work with classifying the information that LexisNexis publishes on various legal platforms. So it's like sorting information, not classified information as in top secret information, just organizing information. And the employer, LexisNexis, gave a conditional offer of employment and said, if your criminal record comes back clean, then the job is yours. Right? The check then came back, there was a record, and LexisNexis retracted that offer. So the applicant referred three disputes. He alleged that the contract was repudiated. He said there was discrimination against him because of his criminal record. And at the end of the day, that was then an automatically unfair dismissal on an arbitrary ground. Him having a record cost him that access to employment. This is how the court dealt with each of these three challenges. The allegation that the contract was repudiated, the court said no, there was a suspensive condition. There wasn't a contract yet. So he was unsuccessful with the first challenge. In terms of the challenge for discrimination, the applicant was successful. The court said yes, LexisNexis did discriminate against you in terms of the Employment Equity Act purely because you had a criminal record. On the third challenge, the court said there was no dismissal on an arbitrary ground because you have not been employed yet. So one of the three challenges was successful. And let's just dive a little bit deeper into this challenge. So we have the Code of Good Practice on the integration of employment equity into human resources policies. And this Code of Good Practice says only in exceptional circumstances can we ask this information and can you possibly discriminate against someone because of their criminal record. Right? So in the LexisNexis case, the discrimination was unfair. To illustrate to you how serious and stern the court is about this, you'll see at the bottom in red, the applicant had the following record: 6 counts of theft, 2 counts of fraud. And still the court said you cannot exclude this person from this particular job. The court awarded the applicant 24 months compensation. And remember, he has not worked 1 day yet. He applied and the offer was retracted because of the criminal record. And it cost the employer 24 months of compensation. This is something that you really need to be very sure of when you enter this terrain. The court did at least give us some pointers to weigh up when can we discriminate, when can we not. So what would be important is the extent of the trust required in this particular job, the level of seniority, and will this applicant or then employee be exposed to sensitive information. Unfortunately, the court didn't give us any pointers as to what would be sensitive information. I can only imagine it can be a very long list. And then any other information linked to the position under consideration. So if I can just give an example, let's say somebody applies to be the head pharmacist at a big pharmacy group, and they do the criminal check, and the criminal check comes back where the person has been found guilty of drug trafficking a couple of years ago, then I think you'll agree with me, if the person is going to have access to a lot of narcotics, Schedule 5 medicines, he's going to be in charge maybe of procurement as well, then it would in all likelihood be fair to say, no, we can't appoint someone who's been a drug trafficker as the head of our pharmacy and procurement, right? So again, if we look at maybe your chief financial officer, it would be fair to do a criminal and credit check and then see if there were maybe financial crimes. But let's say the CFO has a criminal record for domestic violence. We don't condone domestic violence, but in all likeliness, if we look at the LexisNexis case, we would not be able to turn this very competent CFO down because the domestic violence record has got nothing to do with his financial duties that he's going to perform, right? The last comment I'd like to make is you appoint this person, and at the point of appointing him or her, the criminal record was clear. Later in the employment relationship, it transpires that this person has now been found guilty of some or other offense. Again, you will use the same pointers that the LexisNexis court case gave us. The seniority, what information does this person have access to? Is trust an issue? So let's just use the example of our chief financial officer again. If this person has been found guilty of reckless driving and got a suspended sentence, it would not be justified to take the CFO into an incapacity hearing and terminate the employment because of the record. But if the CFO has been found guilty of fraud because the CFO had a pyramid scheme and money laundering on the side, then most definitely, then you will proceed to possibly then terminate the CFO's employment. Remember, as we always say, no matter what transpired in the workplace, always, always have a hearing. Right. So those are just in a nutshell the fruits of our dishonesty tree. And I'm going to hand over to Dr. Newmark to share with us all the very interesting things that comes along with the psychology of possible conduct.
So if I may just ask a few questions on behalf of our attendees, Jacqueline, thank you very much. It's a complicated topic. I think we can probably spend a whole day speaking about that, and thank you for keeping it concise. But a question I often get from my clients is, how much does an employee have to steal before you would consider to dismiss them? Is a 5 Rand theft as serious as 1,000 Rand, for instance?
Bon, to answer that question, luckily we do have case law, and specifically the ShopRite Checkers case comes to mind, where people packing the shelves were dismissed for taking bread rolls and eating just the bread rolls. So the Rand value is not always important. There's usually a vast number of factors to consider. So for one, I think the person's access. If somebody could routinely steal small amounts, and you look at like the the retail environment, and we look at the statistics of how much shrinkage these type of industries suffer with petty theft. So maybe you have this person who stole and ate the bread rolls, no remorse in the hearing, tried to lie their way out of it, short service, then possibly, you know, a dismissal would still be in order, even if the rand value of what was taken was not much. Then on the other hand, yeah, maybe first that you might have some more questions before I elaborate too much.
No, it's such a great comment you make. You know, I recently conducted a disciplinary inquiry for a food franchise. And at the inquiry, there were 3 cases presented on the same day. And the evidence that the employer led was video evidence of the employees in the food franchise as they were doing their work. And the video footage essentially revealed how these 3 employees would essentially walk throughout the food franchise and take food from the serving areas up until a point where the one employee walked all the way to the cappuccino machine and made herself a cappuccino and went back. And so the employer, I think, very, very interesting, presented evidence to say, Vaughan, that one cappuccino costs little, but if you do that 8 times a day, and if you take 8 pieces of bacon from the serving area, that amounts to a substantial quantum damage at the end of the day. And to me, same elements were noted in the Shoprite Checkers case. Where the employees were taking items from the floor, and how Shoprite Checkers had to be creative in terms of their policy, where they, if I recall correctly, they eventually said that you're not allowed to consume any food whilst being on the floor, because they had to try to contain this element of theft. So that is fairly important to me. And then there's the other thing of remorse. Have you seen disciplinaries where employees act grossly dishonest, come to the hearing, and then plead remorse? And what do you generally make of that?
Born in my experience, depending on the environment and the possible impact on the employer, unfortunately, in some instances, no matter how remorseful you are, it comes back to the case that I highlighted previously. So because you are remorseful, I have to give you a second chance. So every person who stole from me as the employer and who shows remorse, I must give all of them a second chance. So for me, consistency is very important to consider. To be more lenient when people come late is different than to be lenient when people steal from you, or possibly steal from other people on your payroll. Or maybe they take that emergency phone away from where it is for a prank, and then there's an emergency and other people suffer. So remorse is important, but I think depending on the impact and other employees then having to get the same second chance. Unfortunately, I think Rona will be able to tell us a little bit more about this, but some people can cry on demand.
Exactly.
No offense, but some people can play the game and they can act extremely remorseful, but there wasn't really a very good reason for what they did.
And what I would also advise, or just a tip that I would like to share with the attendees, is during the investigation, you often find that an employee would deny it or wouldn't reveal the true facts. And then only after having been found guilty would then plead remorse and say, I'm so sorry for what I've done. That to me has always been very insightful. You keep that knowledge to yourself up into a point where it can benefit you, and then you reveal it. To me, that's always been disingenuous. An employee that would acknowledge fault at the onset, and essentially, that legal term. We always speak about employees have to act in the utmost good faith towards their employers. Sorry, that's also in the back of my mind. Has this employee really acted in my best interest? Essentially. Thank you, Jacqueline.
If I may just share one brief example is many years ago, I had a case of a medical rep where they're not always required to be present in theatre when this particular medical product is being used. It's not a requirement. Sometimes they're in theatre, sometimes they're not, but it's not required. So the employer phoned her this particular morning and asked her where she was. And she said she's at the hospital where they're doing X, Y, and Z. And she was not. And within 15 minutes of telling her manager the lie, she phoned back and she said, I don't know why I lied to you, but I wasn't at the hospital. I was still at my child's school. So she immediately realized there was no reason for me to lie, but why did I lie? But she immediately owned up. And that was a very big part of in the hearing, why I did not recommend a dismissal. She did also have long service, but she did not even wait to be caught out. She immediately felt,
and forth. Yeah.
why did I lie? So what you're saying, we see that the court says if you persist with a lie, it's definitely worse than owning up and taking responsibility.
Brilliant. That's fantastic. Thank you very much, Jacqueline. Prof. Newmark, we are waiting in anticipation and we eagerly wait for your insights. If we can maybe move on to your slides.
You unmute me. Thank you. Thank you. Yes, so I'll be, and please call me Rona, I'll be focusing on dishonesty as a pattern in the workplace, also including stealing, and looking at the psychological and behavioral or situational factors that may contribute to such patterns. So there are possible mental disorders, mental health disorders that could contribute to the aspects of dishonesty and stealing, such as impulse control disorder, where you have impulsive behavior, including lying or stealing. And this could point to a disorder where individuals really struggle with self-control. Kleptomania, compulsive stealing, or pathological lying are also conditions within this disorder. Then addiction frequently leads to dishonesty and stealing. This behavior is often driven by the compulsion to secure resources for the addiction to protect oneself from negative consequences. And then we have the personality disorders, where we have antisocial personality disorder, which is characterized by disregard for others' rights, impulsivity, and often a lack of remorse. With borderline personality disorder, it may involve impulsivity as well and instability of self-image, often leading to behaviors like lying for attention or fear of abandonment. When we look at neurodiversity, which includes individuals with autism spectrum disorder, attention deficit and hyperactivity disorder or dyslexia, we can experience different ways of processing information. Managing social cues could be difficult, and responding to stresses could impact on how truth is handled. For some behaviors, such as dishonesty or bending the truth, may emerge as a coping mechanism, particularly when navigating the environment is difficult and the environment doesn't really accommodate their needs. They have to find ways to survive. In ADHD, with attention deficit, for example, dishonesty often surfaces as a method to avoid shame or cover up challenges with memory or task completion. It is less about the deception than actually just surviving and using it as a survival strategy. When we further look at neurodiversity and ADHD-related dishonesty, it can also stem from impulsivity, difficulty to actually keep attention to the task, and memory lapses. This may also look inconsistent in different ways, and sometimes if there's medication involved, if an employee is taking medication, they also have to adjust to medication. So they may have trouble keeping up with tasks, leading up to white lies or ways to avoid negative judgment. Often they also already have a lack of self-confidence in the situation. We can then look at additional contributing factors, such as low self-esteem or low self-worth issues, which could be general or linked to one of the other disorders. Some individuals might lie or steal to gain status or to fit in, or because they feel they are inadequate. stress in the environment also has a huge impact. So high stress, unmet needs, or a toxic work environment can push someone to lie or steal as a coping mechanism. And we also look at situational ethics, where occasionally people may feel that they engage in these behaviors because they perceive the workplace culture to be permissive, or if they feel wronged, or rationalizing why they should do this because it's justified for them where they've been done in some way. They see this as a situational ethics, but they don't see themselves as really as a dishonest person as such.
And Prof, if I may interject, are you essentially saying that there's a difference between some of these disorders causing employees to act dishonestly versus some people that intentionally have a plan to deceit and to possibly gain benefit from it?
Yes, so I think there's such a vast. I think sometimes it's linked to disorders. Sometimes it's linked to just a personality. There's also lying that's not necessarily linked to a disorder. And then there's also situations where an individual feels the environment is really dishonest towards them or disrespectful. And that's where the situational ethics then kicks in, where an employee bargains with himself and decide, no, in this situation, I'm going to protect myself through lying because I don't feel what's happening here is justified. Does that answer your question, Vaughan? I'm not sure if I heard.
No, it does definitely. Yeah, no, definitely. And I think it speaks to that white lie principle as well, Jacqueline, what you said.
Yes.
I've got to avoid this very negative effect that's going to be, and it's almost that impulsive reaction. And Jacqueline,
Yes.
I think you also added to that an employee that has the employer's best interest at heart would come forth to say, listen, sorry, I don't know why I did that, but I want to help you amend what I've done wrong here at the end of the day. But, the trends that we're seeing are far more sophisticated and dark, if I can say that. It's employees that plan certain actions and execute them, and with devastating effect to the employers. It's not those typical just want to cover myself up type of scenarios. You also mentioned something very interesting, Rona, about substance abuse.
Yes, and I think the range. Sorry, did I interrupt you? I think there was a sound lag. Were you finished with your sentence?
There's something else that you also spoke about is the addictions. So in the workplace, we see, we've been dealing with substance abuse as a particularly, I don't want to say pandemic type of problem, but a substantial problem in the workplace. Do you think that there is some correlation or some connection between what we're seeing in terms of substance addictions and dishonest acts?
For sure. I think it's becoming a huge problem. I just see over the last 10 years, I see the risk and the amount of substance abuse challenges increasing all over. And then obviously it plays out into the workplace. So I think it's something that's really difficult to deal with at all levels of hierarchy in the employer, in the company, and often even directors and so it's at all levels. It's not linked to one specific employment status, and I think, but the severity of the fraudulent behavior could really impact highly, and such behaviors are often difficult to change. I'll come to that a bit later in the slides, but it is becoming increasingly more difficult. And I think in that, if there's a lot of substance abuse, your ability, to judge or to really care about the consequences, that starts, you become desensitized to that. So risk taking becomes higher. And, when you think of stealing trucks, so there's often a link with almost organized crime and addiction. One often finds that because it gives often, if someone wants to commit a crime, they feel it gives them courage to actually commit the crime. It desensitizes their conscience. So they don't feel that guilt and they do it with more ease.
It's exactly that word that came to mind. It's as if we see employees not, dishonesty 30 years back or acting with integrity 30 years back seems to be vastly different to what we're seeing today. And it's like employees, don't grasp, or they've desensitized in terms of what is acting morally and credibly and transparently. It's like the norm has changed so much that it's not even considered that serious anymore.
Yes, and the other problem is I think trauma and the impact of trauma is underestimated. I haven't included in the slides, but it's actually captured in most of the disorders. You often, if you have very severe disorders, and often linked also with addiction, there is a history of trauma, and the intensity of the trauma is sometimes really shocking. And I think we actually, especially in South Africa, we underestimate the amount of our community that have been traumatized, the number of individuals. And that in itself has a desensitizing effect, because one becomes less, you care less about a lot of things in life. And in that sense, your survival instincts become much stronger, and you'll do anything to survive. And often you deal with mothers in single parents that really struggle to survive because they have children, and there's a very much a gray area of where's that line where you cross and go towards dishonesty, where you feel you're just not going to survive if you don't take this, and it becomes easier. So it's a very complex psyche and psychology in across the world, but I think especially in our country, with our history, with poverty, with a lot of challenges, and it's the access to drugs across the world is becoming much easier. And so the tendency is to sedate or to avoid. That's why drugs are used initially, but then the addiction starts increasing, and that becomes really difficult. So any further questions on that, or shall I continue?
No, thanks. Thank you. Yeah, you can continue. Thanks.
And you're welcome to if there are any further questions, just interrupt anytime.
Thank you.
So if we look at cues for employers to identify dishonesty, because sometimes if you look at an interview or you have a meeting, one can look at inconsistencies, repeatedly changing stories, or misremembering facts or details. These could be indications of dishonest behavior, but one must also be careful, because it could also just purely be anxiety. Because anxiety is becoming, it's increasingly part of the workplace and of home life. Sometimes it's a fine line of which it really is. Avoidance of details, vague explanations, or avoiding specifics when it could occur when an individual is attempting to hide something. Then one can look at body language. Again, one must just be careful to distinguish between anxiety and dishonest behavior, like nervous actions, avoiding eye contact. All of these can be associated with lying or dishonest behavior. But again, as I said, not definitive. One can also look at discrepancies in documentation, mismatches between documented evidence and verbal statements. These could be suggestions of dishonesty. So if we look at the psyche behind stealing and lying, it often fulfills a need to control perceptions or to avoid negative consequences. And that links to what I was indicating with trauma, fear, insecurity, desire for approval. And I think in this context, the workplace could play a role in supporting individual employees. Stealing might fulfill unmet needs, material or psychological. It could provide a thrill. It could be a learned response, or just getting what one desires. And like we said, if you're more desensitized and you feel, why not? It's available. That could trigger stealing responses. So both behaviors can be mechanisms to cope with low self-worth, psychological distress, or environmental trigger, and mostly it's a combination. So the question is, can this be rehabilitated, if we use that word, or supported or changed, whatever context feels most suitable? So the answer, yes, there is the possibility. I think the severity of the situation will indicate how possible it is. Therapies such as cognitive behavioral therapy can be very useful It identifies the triggers and develops healthier behavior. There are also other deep psychotherapies when individual psychotherapy is indicated. The problem is just whether healthcare funds are available and how accessible these therapies are to the employee. And those are issues we can discuss in questions later. Then counseling, other forms of counseling and conflict resolution, facilitating open discussions to address underlying workplace issues may reduce the root causes of the lying and stealing. So it also, the fact whether it's situational or more really an individual trait will also determine how successful the support is. Then psychoeducation and group therapy, education or educating the individual on healthier coping mechanism and interpersonal skills can really assist in fostering self-awareness and to reduce undesirable behaviors. If we look deeper into workplace strategies, one can have and reassess workplace policies and support to adjust to support the individual employee and the group by providing clear and supportive environment with a set of boundaries and consequences which can help prevent this behavior. An employee assistance program can be very useful in supporting stress and other mental health support. And then behavioral contracts to monitor and to manage if there was a history of dishonesty. In severe cases, one would need very close monitoring along with behavioral expectations, which could provide accountability while building trust. The mental health team on our side in the work we do, we often get involved at this level. We often work with occupational therapists, a psychiatrist, myself as a team, and thorough assessments are done of the individual, and then recommendations are made with the workplace, and we help negotiating or mediating with the workplace to see if support can be provided. And through the support from the mental health team, accountability is required because the individual has to also show that he or she is bringing their side towards showing that they really have remorse and are trying to change the behavior. So creating a culture of transparency and offering channels to minimize the need for these behaviors and to encourage honesty is really important. And then when we look at addressing addiction, it will involve treatment and support for the underlying addiction, which would then also include issues like opening up transparency, setting boundaries in the workplace, but a broader support would be required in terms of focusing on the addiction to assist the individual to turn the addictive cycle around. And here your employment assistance program could also play an important role. So adapting the work environment for neurodiverse individuals is becoming more and more prevalent. It's become more important as many more individual employees are diagnosed, and employers, we assist to sensitize employers to what the needs of an individual with attention deficit or ADHD could be. And this could reduce the stress behaviors and address the root causes of overstimulating in a specific environment. And that will assist the executive functioning. It also helps to recognize the tendencies which are symptoms driven and can guide more compassionate interventions, such as direct feedback loops, supportive routines, and minimizing punitive responses. These strategies really help the challenging behaviors associated with neurodiversity, especially ADHD, because task management and reducing stress then assists that less deadlines are missed and tasks are performed more adequately. So
if I may ask you, you speak about the adaptation of the workplace. Can you perhaps elaborate on that?
Yes, so what we do is, and this is where the occupational therapists play an important role, because I think that it's very difficult for employers to understand when an individual is has attention deficit, how their whole sensorial system works and how extensive visual or sound input could actually impact on their wellness, and it could actually be quite dangerous for them at times, that they cannot cope. And so the occupational therapist would assess the sensorial profile of the individual, and from that, guidelines will be designed for the employer and the individual. So the individual also takes responsibility, and that could be sometimes sitting in a quieter space, having sound deactivating, sound blocking, headphones on. These are simple little tweaks that can make a huge difference in the wellness of that employee. And that's where we become involved. Often we're activists, obviously, for the employee, but we also hold the employee accountable, and we try and find a workable win-win solution for both employer and employee. And so we have negotiations with the workplace and make suggestions, and then the employer has the privilege to say, yes, this can work, or no, it cannot. Or maybe this person, we've often moved employees to different departments where it might be less overstimulating. So there are many options. And if one looks at this creatively, one can really find solutions. We've had employees who've been on the brink of being dismissed, and successful solutions are found, and everybody's happy. And you, especially for the employee, because I think the severity of the stress with an individual with neurodiversity or another mental health disorder is also not understood by employers. And if there's a better understanding, it becomes a collaboration. And that's where I was referring to not having as much punitive responses. The impact on such an individual is much higher than someone who doesn't struggle with anxiety or mental health.
Yeah. And I think Jacqueline, well, yeah, sorry.
Rona, we often get like a medical note. Like, for example, the person has now been accused of something. It might not necessarily even be fraud or theft related. And then the person will bring like a letter from just a GP saying that this person suffers from depression or anxiety. Or in your medical opinion, can just a general practitioner make such a diagnosis to the extent that one could rely on that diagnosis as being true, or should it be a psychologist or a psychiatrist that diagnoses depression and anxiety, or these different things that you've spoken to us? Because we get challenged quite a lot. What do we accept as a valid, genuine diagnosis?
Yes, a GP is allowed to make a diagnosis of depression and anxiety. They are qualified to do that. I think if there's doubt, a referral to a psychiatrist or a psychologist can make a diagnosis, and a psychiatrist and the GP. The psychiatrist is a specialist. So if we're in doubt of the severity and we feel additional assessments need to be done, then it's best to have a psychiatrist referral. But the problem is it's very expensive. If an employee doesn't have medical aid funding, it's going to be very difficult, because then they have to go the state route, and that's a very long process. It's possible, but you won't have a quick diagnosis. So mental health support and overall support is much easier if there is a medical aid benefit with the company, because most medical aids have a 21-day psychiatric benefit, which includes 21 days inpatient treatment. Often with these severe cases where you have behavior due to the mental disorder that could lead to dismissal, we do an inpatient support program where we then do all the assessments, get all the reports ready, and then start negotiating with the workplace, or sometimes if it's a student, with the university. Or they can also apply to the medical aid depending on the fund and have 15 sessions outpatient, which is from the same benefit. So it's part of the hospital plan benefit. So any hospital plan benefit has psychiatry benefit. Your biggest problem is your group of employees who don't have such privileges, because mental health support is really expensive, in the sense, if you want to do the full package, and then it's very difficult to get an occupational therapist assessment, a psychiatrist assessment, and then often you might have to go with a GP. But that would be sufficient for a start, because the GP could give medication, initial medication as well. And what we also do with employers sometimes is to work out a package for an employment, one to see how we can support employees best. Because in the end, I think that's where your employee wellness program could play a role, if the company gives some support, so that individuals don't need to do it from pocket, because often they can't afford it. Even, in your average, your middle class groups, those funds are needed for other survival issues. So I think the employer could play quite an important role in support, if their company support, maybe have an OT, do sessions once a month and do assessments for those individuals who would like to, and because I think that can become more affordable for the employee as well. The whole issue just then that plays a role is confidentiality. I think I mentioned to Vaughan the other day when we had a discussion that employees are a bit cautious if they know the company is funding the support, because they're not sure if issues are confidential.
What I've found also previously, Rona, and depending on one's environment, you might not be aware of these type of challenges, where you have a client who's got a wonderful employee assistance program, and the employees has free access to, I think, something like 9 or 10 sessions, and it can be telephonic or in person. And this particular client even goes as far as arranging a quiet space for the person for this telephone session, because some people live in an environment where there's 2 rooms with 10 people. So it's for a start conducive for that employee to try and have a therapy session in the environment where they live. So there are a lot of things that need to almost be taken into account when offering these type of support, because of people's living conditions that are sometimes extremely challenging for them to even really constructively making use of what is on offer.
Yes, and sometimes you actually need a social worker. We work very closely. Our team at the clinics includes a social worker, especially we have clinic sections which we call DDU, which is a dual diagnosis unit, because mostly when you have addiction, you also have another diagnosis like depression or anxiety or personality disorder. So dual diagnosis will be there 2 problems or 3 sometimes, and a lot of these issues, especially if socioeconomic issues are at play, a social work intervention is often required, and sometimes that type of support really changes a lot for the individual and towards their behavior. If a mother is struggling to sustain her children, a single mother or single parent, it's both mothers or fathers struggle. So that would be, I think, if an employer could have access to a social worker, that could be a good start point to see where the problem actually lies. No. So if we look at, yes, sorry, Vaughan.
Sorry, and we've got some time still left, so I'm entertaining the dialogue. I can see we're addressing some of the questions as well. If I would to put my employer's hat on, my employer has a vacancy and he needs to fill that vacancy with the best suitable candidate. Now he employs an employee, and only after employment has commenced do these personal problems emerge that now require an employer to assist and to coach. I've got a funny feeling that a lot of my employers are going to say, "But that is unfair. I didn't know that I'm in for this when I appointed." From a legal perspective, Jacqueline, what do you think can employers do to make sure that, number one, we don't discriminate based on unfair criteria. And number two, how employers can make informed decisions in terms of when they employ, they know what their part or what they're going to have to do to make, to help the employee champion their job.
Vaughan, there are almost like a web of aspects that would come into answering this question. First of all, the employer is entitled, when they engage with an applicant, to expect that employee or prospective employee to disclose any condition that may negatively impact their ability to perform the job that they are being appointed or considered for. And Rona, I think you will be able to also guide us here. I would answer the question in the following way, and I'll take myself an example. Let's say, for example, I suffer from depression and anxiety, or I'm bipolar, but I'm receiving treatment. I go to my psychologist or my psychiatrist often, and I'm actually doing well. And I haven't had, I don't know what the correct term would be, like a relapse or anything like that in a very long time. I don't necessarily think I need to disclose that because I'm being treated and I'm doing well. If then later in my employment journey, I do have a relapse, as an employee, I would be able to say to the employer, but I was not irresponsible with this. I've been under care, I've been taking my medication, because it's a fine line between discrimination and the employer's rights to run their business in a well-functioning way. But let's say, for example, I have a degenerative eye disease and I'm applying at an airline to be a pilot. Surely I have to disclose that. So if then later there's, maybe for some or other reason, the medical wasn't done or whatever, something fell through the cracks, I was appointed as a pilot, and then later with the annual medical, it's picked up that I've got this degenerative eye disease, and in 8 months' time, I won't be able to actually meet the requirements medically, then the employer would be in a position to look at a process to exit that individual from the business, especially if there aren't any alternatives or, any cure or treatment, for example. So what I would like to say is it would very much be a case-by-case situation. And like we all know, employees do not have to disclose if they are pregnant. They do not have to disclose if they have HIV. Something like TB, which is a communicable disease, that is something that a person would have to disclose, to say, maybe I'm having a virtual interview, so I'm not there in person. I don't have to wear my mask when I'm being interviewed at home. Then I need to say to the panel, I actually still have 6 weeks left of my TB treatment. I won't be able to start in 4 weeks' time. So it will very much be case-by-case basis. Rona, I don't know from your perspective, medically and ethically, if you have other comments or views on disclosure.
Yes, thank you, Jacqueline. I think I just want to go one step back. And the bad news is if we look at the word stress, and stress is the underlying factor linked to mental health and physical health. I think no person is actually excluded from that. So I think what employers need to know is that the amount of individuals with acute stress in their workplace, if they actually do the stats, will be quite shocking. That is the majority. So including proper mental health care and physical care in the workplace has proven that for sure your productivity is going to increase, because the moment there's stress, your productivity will decrease at various levels, or you may become ill and then you have absences. So that's just the first point in terms of emphasizing the importance of some form of support, that it's not for a few individuals, it's actually for the majority of your workforce. It's vital. Secondly, then coming to disclosure, we have the Constitution and the Mental Health Care Act protecting individuals in terms of privacy, and secondly, not that they have the right not to be discriminated against. And these are really important matters to take in consideration, because it is actually disturbing to see how much discrimination there is related to mental health issues. It's still, the stepchild in health, and that's where we are very strong advocates for that, because we see how people suffer, and if you lose your income, everything else goes. It's really difficult for individuals, and that's where they will often not disclose, because there's still discrimination, and they have the right to keep it private. Even when we do diagnoses, some individuals don't want us to use their medical aid because they're scared it's on their record somewhere, and they're worried if they apply for work that it would be disclosed or asked, and they just want to keep it neutral. Yes, so it's quite a sensitive topic, but I think it's vital. I think the amount of anxiety and the impact of anxiety and stress, which are totally directly related, has the potential to impact more and more on the topic we're talking about, but also broader. And I don't think employers could really ignore it. I think if you want to look at productivity and support, those are going to go hand in hand in future.
Sure. And Rona, have you found that employee wellness programs that you've been or that you've seen, that they've contributed or helped at all?
I think the programs look good, but they're not necessarily implemented efficiently. So I think there's good intent, but the implementation is vital. But where there is a supportive program in terms of coaches or support, it definitely has an impact, and it really assists employees. And if there's some collaboration between company and the medical aid, because medical aids often render quite a few services like dietitians or additional sessions. So most medical aids are really proactive in health at the moment. And I think those are things then to look at. What can we offer for our employees where there's no medical aid available? Because within the medical aid, as I said, within that context, come together with the employment wellness program, one can really develop something that's successful.
Yeah, and I think for employers, we know that our personal lives are becoming more complicated. We know that trauma is more prevalent. We know that our young employees are exposed to much more stresses than what they probably should be. And I think it's probably naive to think that you would employ not having that background or history impacting you. And hence why it might sound unfair, but it is almost impossible for employers not to intervene, to say, well, we've got to do something. However, I think that the collaboration or cooperation of employees would probably be very important. You might have these beautiful interventions, but employees might not follow it. And I think, Jacqueline, that's where the code of conduct then kicks in to say, well, I've now helped, and now I set down the rules. But it's always that difficult balance. You want to help, but you also need to maintain that culture of integrity and honesty, essentially, which is tough. I've got an interesting.
And I think.
Sorry, Rona. Yes.
I think that's the difficulty, is the range of the situations you deal with, because where you have outright criminality, often gangster activities, it's very difficult to, even in prisons, and it's not easy to change behavior. So it will be long-term support programs, and I mean, it obviously links to our whole environment of support on societal impact. So it's a much broader problem. But I think if different groupings work together, I think it's easier to start bringing some shift in the activities, because you have this broad range, and we're talking about a range in the middle perhaps and severe. But the most severe situations, I think the employer is going to struggle to have sustainable support. That will become expensive because it will be long-term.
Impossible. Yeah. Jacqueline, a legal question for you. One of our attendees has asked if an illness or disorder is used as a mitigating element to lessen the sanction. Have you seen some of those, and especially with regards to dishonesty case, relevant cases? Do you think that it has any impact?
Yes, well, I think it ties in with a question that I asked Rona as well about diagnosis, because there might be some of the more serious personality disorders that Rona touched on. I mean, let's say, for example, I am chairing a hearing and it's for theft, for example, and then as part of the individual's mitigation, they raise that they are diagnosed as someone who is kleptomania. If that diagnosis is then from a credible source, I would definitely have to consider it. But then one would again have to assess the environment to see if we have to weigh up the rights of the employer and the employee. Is there a way in this particular environment that we could possibly accommodate this individual? Because we cannot necessarily say that someone with a compulsion to steal should not ever be allowed anywhere in society or in any workplace. It's a very difficult scenario. But I think with these very serious disorders, I think if the diagnosis is from a credible source, one would have to look at it and see if you can still accommodate that individual in your business. I think, again, the role that this person is appointed in, the type of transgression, that would all come under consideration. But you would have to take a very close look at all of these factors and then make a very informed decision. What I find is, if I can use a recent example where the employee brought a fraudulent medical certificate. There were discrepancies on the actual certificate where things were changed, but also she then disclosed that actually she was never at the doctor. A friend went and got the note on her behalf. And then she raised that she's got anxiety issues as mitigation. So then the question becomes, if anxiety makes you incapable of distinguishing between right and wrong, it becomes very complex. Yes. And I'm not pretending to have all the answers. All I'm saying is that all of these things will have to be considered very carefully. And I think that is what is wonderful for me about Vaughan, what we're also doing this morning, because I would, for example, be able to pick up the telephone and phone Rona and say, Rona, as a psychologist, this is what I'm confronted with, without disclosing names, but to just share the gist of the incident and the situation and get a professional opinion weighing in on that decision. Because as legal practitioners, we are not psychologists and psychiatrists.
Yeah. To me, what has been impactful over the years is John Grogan speaks in his book on dismissals. He speaks about mitigation. And one of the key things he there speaks about is it references the fact that can you as a chairperson have the confidence to know that corrective disciplinary action would prevent a similar occurrence in the future? And I always take that away with me when I have to mull over my recommendation on sanction. Now, can I go to bed at night comfortably knowing that whatever corrective disciplinary action has been followed would serve to rehabilitate or correct the employee's conduct? And the problem with dishonesty goes to the root of the employment relationship, that trust. Once that trust is broken, it's so difficult to go back and to try to repair it. So my take on it is, I don't think that mitigation by itself is an automatic excuse. I think the employee somehow needs to present or argue how they intend to breach this trust gap and to repair it again. So I don't think it's for the employer to repair it. It's the employee's duty to repair it, because they've essentially breached that trust principle. So,
what I do want to touch on that Rona also mentioned is, if there is an environment at work where people feel safe and they feel that they can, in a safe space, trust their manager or human resources by disclosing certain things, prevention would also then possibly become an option. Yes. Where somebody comes and volunteers the information to say, I have an addiction problem, I have financial problems. So before it's at the point where I feel I need to steal from a colleague to feed my children tonight because I'm a drug addict, people should know about these support programs. Not everybody's going to make use of it. I mean, I chair or facilitate counselings where people have been referred repeatedly, had time off to attend sessions, and still you can bring the horse to the water, but you can't make them drink. And then other employees will sometimes come back in a follow-up counseling session and say, you know, I'm so grateful for what the employer has arranged for me. The sessions are really going well. So we do see success stories, but it's very much also for the employee to sometimes take that leap of faith in trusting the employer, trusting that assistance program, and to make use of the support and to come and share. But I know it can be very difficult. If you don't want your personal issues maybe gossiped about in the tea room if your manager was not. You know, all of what we've discussed this morning is very difficult.
Yeah, very sensitive. I've got more questions on the group, but perhaps not so much related to dishonesty. And there was one question with regards to disclosing a medical condition when you've got to start working. I think, Jacqueline, you've already dealt with that in terms of what needs to be disclosed. And what I will do for the attendees in terms of their questions that they've raised that are perhaps not related to dishonesty, I'll answer those. And please feel free to reach out to us. Our team of experts are always more than eager to assist to make sure that you manage your employees fairly. So up until this point, I think we have reached our end. Rona, thank you so much for your time and for the effort and all the preparations. I know this has taken quite a lot of time, but your contributions have been incredible. And I'm really excited to be, for us partnering with you in the future if we need your assistance again. So thank you very much. And Jacqueline, to you as always. You put a lot of effort into these webinars, and I'm hopeful that the content that we've shared helps or at least contributes to our attendees today. So thank you very much. And to the two of you in the beautiful Cape Town, I hope you've got good weather and hope you have a beautiful weekend.
Thank you. Have a good weekend. Bye-bye.
Keep well. Bye.
Bye.